what we are seeing is that it is used to basically subvert the evidence. Uh, and another problem is that the police officers who are going to see these post-mortem reports and cases of hanging and cases of poisoning and things like that, they are probably not taught the issues as how to read a report. And sometimes an SHO would ask, well, please have a look whether this is a suicide or a homicide. And he cannot really understand the report. Obviously, this means an underreporting or a misreporting of evidence of crime. This will lead to this. To add problem to this, during the General Zia era, he tried to introduce some Islamic things into the law, including in the punishment section, and some very fancy Arabic names were given to various types of injuries and so on. But even in that, it appeared that the selection of the terminology and the punishment associated with it did not actually tally with the exact medical and surgical science, which basically meant that there is a scope of the problem. Now, I'm not surprised at this. In a country where the national identity card would not have any name of yours written in any foreign language like English or something like that, so obviously it leaves a scope for various types of nefarious activities. One other aspect is that during the time of the British, interestingly, when the doctors were recruited in subcontinent, they were given a very specific instruction. They were told, well, your primary duty is to maintain law and order, which is very surprising, because you expect an assistant civil surgeon to be told that your primary duty is to take care of the patients and so on. But that was to emphasize to them that the aspect of your work which relates to the accurate post-mortem reports and this thing and that would be basically watched, because that would be one of the main criteria of your being retained in service. Second thing is that even in small stations, from time to time, during that time when there were far fewer doctors, far fewer surgeons, there were surgeons who were qualified from the United Kingdom, FRCS and so, who used to rotate or come or visit or supervise even smaller towns, the civil surgeons and so on. Which after the making of Pakistan, the problem became that the work of the casualty medical officer, which was or a civil surgeon, that was not really well supervised, that what he's writing and how will he get trained in the art and so on. Although for some years we do have now people who have got degrees in forensic medicine, and they are put in these departments for some years. However, even now, we don't see, except in special circumstances, very highly qualified people doing the various giving medical legal opinions, except in certain cases. We don't see on the spot medical tests being conducted for alcohol or for drugs or something, and there's just tendency of just packing the thing and get the urine or something sample and send gastric aspirate and send it to a centralized laboratory in some other city. Obviously, this will result in the loss of evidence, and it can also result in substitution of evidence, substitution of samples, and all types of errors, besides the degradation of the proteins and other things which are required in a proper analysis. So basically, the system doesn't work that well. Uh, and interestingly, instead of the reliance being placed so much on the doctor's report and certain forensics or so on, a lot of emphasis is on the visual evidence. Now, about visual evidence, less said the better. The problem is that when a society is a clannish society, when a society is a brotherly-ridden society, and children are not really taught to give correct evidence and understand the importance of evidence. If you ask somebody, well, my friend, I need a witness for my thing, which you also saw the event or something in a court case against me, and his first question, no matter how literate he is, would be, okay, what am I supposed to say? Now, this is very sad because he is supposed to be a witness, and the terminology used in courts of petitioner's witness and defense witness and so on exacerbates the issue, because a witness in the Islamic society is a neutral person. He has to just report what he has seen, or he might have been presented by the defense or the prosecution for his case, but he is basically a human being who is given witness in the court. Then, of course, there are clashes in the witness law between the Western and the Islamic system. Although there was a change in nomenclature of Evidence Act into Qanun-e-Shahadat, and sections were called articles and so on and that type of thing. But the thing is that it was essentially the same, and there was no change in the thing. Well, there is a merit of proceeding slowly, because there is a huge wealth of case laws decided by the various Supreme Courts based on this in both India and Pakistan, which can sometimes help solve the matter. And if we change the law radically, obviously we get to lose that type of wisdom. But even in that count, the problem is that the Supreme Courts of India and Pakistan, they tend to make different suggestions, different determinations on the same issue from time to time, which means that the case law tends to get diluted in terms of its importance. However, lately there have been a few things. For example, the appearance of liars who really do not qualify fully for being called to bar. There are certain mechanics in place now trying to stop such people from appearing in smaller places. There is also written exams which have been put on for the judges to pass, rather than just sifarish or recommendation, as it is called. But still, there is a lot of scope of improvement. I was observing a murder trial in the newspapers not too long ago, which is yet to conclude. And I was observing that how people select their liars. Some of them would select just their somebody they know for a long time. Some of them who are a bit more experienced, they tend to select liars who are from in other district, so that they have got less opportunity to mix up with the opposite liars and make some arrangements or something. It's a hope which they have. Then there are those who have got the money and everything, and they tend to select liars whose names they read in the papers. One day, a leading liar of Pakistan said, "Well, you know, uh, the thing which really helps in the clientele, to get the clientele, is not the repute which you have in the newspapers, but the repute you have got in the jails, that such and such person can get you out of the kotri. Kotri is a very problematic concept. It's a very small place where people who are sentenced to death are put in, and it's really inhuman thing. I'm surprised that no human rights organization as of Pakistan has taken up the issue of these coteries, particularly when the uh, the person who has been convicted but who is waiting appeal. His appeal might take 7 years, 8 years, and you can see people in lawyers' offices who have spent 7, 8 years in the coterie. It's a kind of dungeon, um, and you may be allowed, let's say, about 1 hour of walk some in a day or something like that, and you might be clearing your own refuse and so on. And uh, and they've spent 7, 8 years in coterie, and then they somehow the appeal was accepted by the Supreme Court or High Court or whatever, and they were released. Now, in the civil cases, the issue is a bit different. In the civil cases, uh, the litigation tends to be very long, because in the criminal case, the hearing is supposed to occur in, let's say, around every 10th day, 15th day, or something like that. But in civil cases, because of the great profusion of cases, the case would be heard probably every second month or something, and then there will be adjournment, so that in a particular year you might get about not more than 3 or 4 effective hearings in which some progress is made. It is a very common culture in Pakistan that whenever you file a suit against somebody, he would take 1 or 2 sections from the law which states that, well, the thing is not maintainable under or section this, order this thing, that thing, that thing, 711 or whatever. And in that case, if that doesn't work and the case goes on or something like that, somebody might at some stage in criminal case or even in civil case would say, no, um, uh, there are sections, well, there is no possibility of punishment in this, and under section 265K CRPC, or there's a equivalent civil section and so on, you can just uh, discharge the case at whatever stage. Um, Having crossed this thing that the case, will begin in earnest, and usually after these, the person not appearing, opposite party not appearing in the court, and then you see there's month, 2 month period between the various summons, and he doesn't appear, and then there's uh, a news, there might be a newspaper advertisement, and you have to put that, and you have to fund this, and then after a few months he would appear, and then he will start filing the things which I have said, and the case would actually start in earnest at around the maybe even 5th month, 6th month, 8th month, depending on how persistent is your liar. Even in criminal cases like the Illegal Dispossession Act, which are supposed to have day-to-day hearing, and need to be solved within about uh, 60 days or something like that. Uh, it is very common that even in the charge is framed after about 4 or 5 months, and then the hearing. And I know a case in which it is the probably the eighth year or ninth year, and there are still certain things and some funny orders made in the lower courts, and they are being heard in the high court, and in the and that is because of COVID, that is not passing through, and so on. And this type of thing, is quite common. So they say that there's an adage that in a civil case, when the case gets started by the grandson, uh, it was started by the grandfather and it ended with the grandson. This is sometimes quite correct, and this is what actually happens. Um, Obviously, this is not a legal system in that sense. However, I remember a description of Francis Bernier, a favorite author of mine during the time of Aurangzeb. He says in 1600, and I think it's around mid 1600s, he said that today I visited a court of the Mughals, and the total proceedings during the court, um, including the penalty, took 2.5 hours. And now, obviously, this is a bit too fast, I must say, um, and it has its own demerits. But and he also writes that, well, if this case had been in Europe, it would have taken a much longer time and considerable fees. In other words, that even at that time, there was a remarkable difference between the speed and the way the cases are fought. A objection which is often raised about the Anglo-Saxon legal system is that can a liar in Islamic setting represent a client when the client is not a child, is not a housebound lady, is not mentally retarded, is not an old person who can be subjected to this thing, or can he represent him? Can he go to the court and start arguing that I did this thing, which is a common thing, as they are in the shoes of the person who hired them? Uh, this is a great question. It's not that the concept of a representative is not there in the Quran or Islam. It is there, and the word wakil is very much there. But it is not envisaged that a case would be really followed in a way in which at crucial parts of the case there may not be any accused present, or the person is quite okay, he is quite intelligent and everything, and a battle is going on between the wits of the two respective liars rather than the person speaking himself out. I think this is a great question mark. Uh, Apart from the punishment system, which I alluded to before in the earlier part, this is another question mark whether this is a permissible system in terms of the Islamic things, in terms of somebody who is adult, who is educated, who knows whatever it is, and he is still being instead of him giving directly dealing with the court, and the liar is dealing with the court. On the other hand, this has got one or two positive things in the sense that it tends to reduce some of the risk to the judges, and it also reduces the heat of the thing. And true that if the case goes on a bit long, there is always a chance that the parties might like to withdraw the case, and there are some judges who do these adjournments frequently with the hope that if the case is not really that impassionate type in nature, the two parties might reconciliate with each other, and the case gets dropped.